Hi, everyone. Good morning, good afternoon, and good evening, depending where you're joining us from. My name is Tamara Kharroub. I'm the Deputy Executive Director and Senior Research Fellow at Arab Center, Washington, D.C. I'm pleased to welcome you all to today's webinar, focusing on the targeting of Palestine activism in the United States and its suppression of constitutional rights. The last years, as some of you may know, have seen a significant increase in activism and support for Palestinian rights in the US. But as support grew, so did the efforts and attempts to crack down on Palestine activism and silence advocacy for a change in US policy towards Palestine and Israel. A variety of suppression and repression tactics have been used and recently intensified, specifically in the US, but also around the world. And they've intensified in order to pressure groups and individuals who support Palestinian rights and those who criticize Israeli policies against the Palestinians. These tactics have ranged from censorship of speech in support of Palestine to disciplinary investigations and dismissals, especially on college campuses. We've seen false accusations of antisemitism and terrorism charges, intimidation and smear campaigns, media and social media bias and censorship, legal threats, administrative sanctions, and various legislations at local, state, and federal levels. Legislations that criminalize support for the boycott, divestment, and sanctions movement, and that punish advocacy for Palestinian rights. We at Arab Center Washington, D.C. sought to organize this webinar to discuss these efforts to suppress and criminalize the movement for Palestinian rights and the implications of these measures and attempts. What forms are these suppression efforts taking? Where are they concentrated and what is their goal? How have they evolved over the years? What is being done to challenge these measures and protect the rights of US citizens? Can they succeed in silencing Palestine advocacy in the US? And what are the implications for constitutionally protected rights overall in this country? To address these issues and answer these questions, we are very fortunate to have an excellent panel of experts today who have taken the time to be with us and share their insights. I will briefly introduce our panelists in speaking order. And you can look up their bios online. They all have a long bio and a long history of achievements and experiences. We'll start with Yousef Munayyer. He is my colleague and Nonresident Senior Fellow at Arab Center, Washington, D.C. LaHood is Deputy Legal Director at the Center for Constitutional Rights. Brian Hauss is Staff Attorney with the Speech, Privacy, and Technology Project at the ACLU, American Civil Liberties Union. And Meera Shah is Senior Staff Attorney at Palestine Legal. Thanks to all of you for joining us, and I look forward to your contributions and analyses. Before we start the discussion, I would like to remind our audience here, you can send in your questions at any time. Feel free to send your questions through the Q&A feature on Zoom or by email if you're watching on our website or social media. The email is events@arabcenterdc.org. Please identify yourself and your affiliation and indicate to whom your question is addressed, if specifically addressed to one of the panelists. We will try to take as many questions as time allows. The format for today is pretty straightforward. For those of you who've attended our webinars in the past, it's a similar format. I will give each panelist about 12 minutes to present their remarks, and then we'll spend the last 30 minutes answering questions from the online audience. And with that, let's start the discussion. We'll begin with Yousef, who will provide an overarching assessment of their repressive efforts and the history of the strategy behind it and how it has evolved over the last 15 years. Yousef, the microphone is yours.
Thank you, Tamara. Good morning, everyone. Very excited to be talking about these topics here and to be part of this outstanding panel that's really going to dig into some of these issues in detail. So really looking forward to this conversation and questions from the audience as well. My task is to sort of frame this conversation and also give some background and context into the extent of what's going on and sort of where it came from and the strategy behind it. And I want to provide a little bit of context to help us do that. First, some historical context, which I think is important. What we are talking about today is essentially the repression of global dissent around Israel's policies and treatment of Palestinians. And while this is something we are seeing today, it's important to remember that Israel's repression of Palestinian dissent is something that is as old as the state of Israel itself, and has been practiced and has existed on both sides of the Green Line over the last 75 years or so. And I'm talking here not just about the repression of Palestinian armed resistance, but also the repression of Palestinian civil society in Israel and the territory it occupies as well. So what we're seeing now is not something that is fundamentally new, but something that has transformed and internationalized to target dissent against Israeli policy across borders. And so that's the first sort of piece of historical context that I wanted to offer to frame our discussion. The second is that while today we are going to be talking about this dynamic here in the United States, it is not only happening here in the United States, but these efforts are happening in many places across the globe, here in the United States, but also in Europe as well, in many different countries, where we are seeing efforts through laws being passed, lawfare being practiced to target and silence dissent against Israeli policy and treatment of Palestinians. So this is, while again today we will be focusing here on the United States, this is not only happening here in the United States. And that brings us to sort of the third piece of context, is that this is not sort of happening in a haphazard way or out of coincidence, but rather this is an effort that is being supported, coordinated, and encouraged by the Israeli government itself through its official channels and its unofficial channels as well. And I want to talk a little bit about that and how that has evolved over time to bring us to the moment that we are in today. This, of course, has happened significantly over the last 15 years. Concurrent with a pretty extreme shift in Israeli politics further and further to the right, which I think is important because the sort of ecosystem of organizations, politicians, and financial supporters of these efforts exist largely within the right-wing sphere of Israeli politics. And as the political parties that represent the Israeli right assumed greater and greater political control over government, we saw a concurrent growth in policies of repression and the internationalization of repression through the organs of the Israeli government itself. So I think all of that is sort of important context to begin with. Historically, I would divide this into basically three different periods over the last 20 years or so. From 2005 to 2010, let's say, then from 2010 to 2015, and then from 2015 through today. And I want to talk a little bit about each of those periods and how things have kind of changed. Of course, in the mid 2000s, we were really in the midst of the second Palestinian uprising, the Intifada. We saw the complete breakdown of the quote unquote peace process, and for those who bought into the belief that there was going to be sort of an internationally sponsored diplomatic solution to the plight of Palestinians, that of course crumbled during that time and has only continued to deteriorate since then. And this gave rise to growing global civil society efforts to demand accountability, as it became clear that the United States' mediated peace efforts were not going to bring justice for Palestinians, as it became clear that the international community was not going to be able to do that, global civil society increasingly stepped up with demands for accountability, led really by Palestinian civil society and through the Palestinian call for boycotts, divestment, and sanctions, which was modeled after, of course, previous transnational advocacy campaigns like the anti-apartheid movement, which called on global civil society actors to stand in solidarity with the people who were oppressed by taking the actions that they could in their own communities through these different tactics: boycott, divestment, and sanctions. And from this time through 2010, you saw the increasing growth of this movement. And importantly, the end of this period was, of course, capped by a major and horrific event, which was the massive war on Gaza from the end of 2008 into 2009, which was in many ways a paradigm shifting event and a scale of attack on Gaza that we had not seen before, and also an event that turned many, many more people away from supporting the state of Israel and really added fuel to this effort internationally to demand for accountability. During this period as well, towards the tail end of it, we began to see growing attacks within Israel against left-wing groups within Israel, or so-called left-wing groups within Israel, human rights defenders, and NGOs that supported a more critical stance towards Israel's treatment of the Palestinians. And we began to see laws being passed inside Israel targeting these NGOs, scrutinizing their funding, and laws being passed inside Israel as well, targeting things like expression of commemoration for the Nakba. And so there was this sort of growing pattern of steps being taken by the Israeli government to silence both those who were critical of Israeli government and those who were expressing any support for Palestinians as well. In 2010, of course, we saw the effort to break the siege on Gaza by a flotilla of boats that was also led by members of global civil society, which was a moment that really shocked the Israeli political establishment into action around further repression of any kinds of global civil society efforts. And this was seen as sort of a wake-up call within Israeli policy circles to shift their approach towards international criticism and dissent within global civil society. And this brings us to sort of the second period from 2010 to 2015, where you have this growing debate in Israeli policy circles over how Israeli government policy should shift to dealing with this issue. And there are largely two camps within Israeli policy circles on how to deal with this issue. One could be sort of characterized as the Hasbara camp or the diplomacy camp, which says, you know, we need to just do a better job explaining the Israeli story, telling our narrative, showing people what's great about Israel, et cetera, et cetera, et cetera. And if we do that, then that's the best way to sort of combat criticism of Israeli policy towards Palestinians. And another side is a side that really grew during this period and ultimately ended up winning the debate. And that's the side that said, no, we can't just practice diplomacy. We can't just talk about our side of the story. We actually have to go on the attack. And this is really important because this characterized a shift in Israeli government policy towards global civil society dissent that ended up becoming formalized in organs of the Israeli government. And this was a policy that was developed by an Israeli think tank that was very close to the Israeli government called the LaHood Institute. And they argued for several sort of central principles in a new policy towards addressing the challenge of global civil society dissent. And this was one of the key principles. Shifting from defense to offense is how they characterized it. And in other words, instead of explaining themselves, they would attack the sources of dissent. And this became a central pillar of Israeli policy moving forward. Other principles included the idea of it takes a network to defeat a network. And so the Israeli government began moving towards establishing a network of allies, which would help it extend its coercive force transnationally across borders. So in other words, it worked with partners, like-minded partners, excuse me, in the United States, in Europe, and elsewhere to advance certain repressive objectives like anti-BDS legislation, like lawfare campaigns, like smear campaigns, like the targeting of students at campuses, all of which we're going to talk about in greater detail. And in 2015, this became formalized in Israeli government organs through the creation of something called the Israeli Ministry of Strategic Affairs, which was handed a mandate by the Security Cabinet in Israel and a significant budget with which to carry out these objectives, to build and support a network of allies that could advance these repressive efforts across borders, and the funding with which to carry this out. And so in the years since 2015, we've seen a significant escalation in these efforts, not just in anti-BDS legislation, but in lawfare attacks and in smear campaigns as well. And most recently, and I think importantly for the future, the effort to reframe dissent against Israeli policy towards Palestinians as anti-Semitism through the passage of laws, regulations, which adopt a definition of anti-Semitism that can easily be construed to cover most forms of criticism of Israel. And this is an effort that is intended to target dissenters, and to do so in a way, I think, and I know that both Brian and Meera will get into this in greater detail, that can help them sidestep the challenge of this very important thing we call the First Amendment, or free speech protections here in the United States. Because if criticism of Israeli policy can be framed as discrimination, it's a lot harder to defend on First Amendment grounds. And so we are seeing a shift today, within this repressive effort to move towards greater use of this definition of anti-Semitism, greater adoption and enforcement of it, in the hopes that it can have a repressive effect against dissenters, while also sidestepping some of the challenges that we see anti-BDS legislation coming under because of its violation of the First Amendment and free speech principles. And so I will stop there. I know there's plenty more to say on this, and I really look forward to hearing what the others have to say and can add more in the Q&A, but wanted to provide sort of that context for our conversation. Thank you.
Thank you, Yousef, for this really great comprehensive overview and context. I think it's a great setup for the rest of the discussion as we get into more details in discussing these tactics and repression efforts. Next, we have Meera, who will focus a little bit more on lawfare against Palestinian rights activism and the suppression of speech on Palestine and the constitutional rights of these activists. Meera, you have 12 minutes.
Thank you. Thanks, Yousef, for that great overview. And thanks to the Arab Center for hosting this conversation and inviting me and all of you who are attending. The Center for Constitutional Rights is a nonprofit based in New York that was founded in 1966 by lawyers supporting the civil rights movement in the South. And we continue to support movements for social justice to this day. Over a decade ago, we started getting calls from activists and students in the US who were facing suppression of their advocacy for Palestinian rights. I don't really use the term lawfare just because it has so many different definitions. I think about using the law to expand and enforce rights and seek justice, which is something we do. And I think of, sometimes people use lawfare to mean abuse of the law to silence political opponents. And that's basically how I think about it. So we were contacted first by activists in Olympia, Washington, after the Olympia Food Co-op became the first grocery store to boycott Israeli goods in 2010. And the co-op's a nonprofit that has a long history of doing social justice work, and Olympia is home to Rachel Corrie and Evergreen State College, where she went to school. I don't know if people are familiar with Rachel Corrie, but she was a 23-year-old US citizen who stood in plain sight in front of a home in Gaza, trying to protect it from being demolished while the family was inside, when she was run over and killed by an Israeli soldier in a Caterpillar D9 bulldozer. So the Olympia Food Co-op Board passed the boycott, and 5 of the 22,000 co-op members sued the board members to stop the boycott and seeking personal damages against them. Stand With Us, which is one of the many groups trying to suppress speech critical of the Israeli government in the US, took credit for filing the case and said it was a byproduct of its partnership with the Israeli Ministry of Foreign Affairs. When asked about it, the then Deputy Foreign Minister confirmed that indeed the ministry uses Stand With Us to amplify its power. This was before the Ministry of Strategic Affairs was getting involved with these kinds of suits. So CCR teamed up with Davis Wright Tremaine, and we filed what's called an anti-SLAPP motion. SLAPP is a strategic lawsuit against public participation. So basically a meritless lawsuit that targets protected speech. About 31 states and DC have anti-SLAPP laws that deter the abusive use of courts to chill speech by permitting early dismissal of the case and often granting attorney's fees. So in 2012, the trial court dismissed the complaint as a SLAPP and awarded the board members fees and statutory damages. But the case went up to the Washington Supreme Court, which struck down the anti-SLAPP law and sent the case back. Washington State has since adopted a new anti-SLAPP law. So the case went to discovery, and plaintiffs demanded our clients turn over all documents they had regarding boycotting Israel. So every mass email they'd ever received, every social media post, diary entries, anything. But the plaintiffs who had sued are also subject to discovery, and they produced documents in which they celebrated that this lawsuit had successfully discouraged other co-ops from taking similar measures, and thanking Stand With Us for providing the legal team and raising all the money. So it's clear, it was always clear, but this made it even more clear the real purpose of this lawsuit. So the case was dismissed once and for all a couple of years ago, which was 10 years after the boycott was passed. So the impact on our clients of 9 years of litigation was real. It was intimidating and stressful and time consuming. And that was with pro bono counsel. When they needed a loan or wanted to buy a house, the case would come up. So I have a current case that's very similar. In 2013, the American Studies Association passed a resolution endorsing the call to boycott Israeli academic institutions. And it wasn't the first, but it was the most prominent faculty association to do so at the time. And the ASA passed the boycott resolution because Israeli higher educational institutions are complicit in Israelis' human rights violations, and because of the lack of academic freedom for Palestinians. So following the resolution, the ASA faced an onslaught of attacks. They received hate mail, death threats, legislative efforts to punish them, and several legal threats and complaints. One of them was filed in 2016. It was actually filed a few days after the American Anthropological Association started open voting on a boycott resolution that was open for 6 weeks after that. So 3 years after the ASA's boycott, a case was filed by the Brandeis Center, and they sued the ASA and the individual members in federal court. The Anthropological Association ended up rejecting the boycott, and so did the Modern Language Association after that. But other associations have passed boycotts. So this case was litigated in federal court until it was dismissed in 2019 because the plaintiffs didn't allege sufficient damages to be in federal court. So plaintiffs then sued in DC Superior Court. CCR represents one of the defendants, Stephen Salida, and we and other defense counsel brought anti-SLAPP motions. There's no federal anti-SLAPP law. Some circuits have applied state anti-SLAPP law to federal cases, but DC is not one of them. So Stephen has been sued simply for advocating for the boycott. He later joined the National Council, and he is sued also because he happened to be a member of the National Council when the ASA spent money to defend against this very case. And he's the only person who is on the National Council, who was sued after the resolution was passed. So the court dismissed some of the claims, but not under the Anti-SLAPP Act. So we appealed, the Court of Appeals reversed and remanded, so it's currently back in the Superior Court, and our anti-SLAPP reply brief is due tomorrow. But the case is already 6 years into litigation. So, you know, the purpose of chill is affected. Another case that's a bit different, but similar chilling effect, CCR is representing the US Campaign for Palestinian Rights, one of the oldest Palestine solidarity organizations in the US, which Yousef used to direct. So the US campaign was sued under the Anti-Terrorism Act in DC federal court by the Jewish National Fund and some US nationals living in Israel. The Jewish National Fund, if people aren't familiar with it, predates Israel in taking Palestinian land to be used solely to benefit Jewish people. And the Anti-Terrorism Act is a federal statute that permits US nationals injured by an act of international terrorism to bring civil claims in federal court. The lawsuit was reportedly crafted by the International Legal Forum, which receives funding from the Israeli government. So the JNF argued that the US Campaign for Palestinian Rights is liable for damage to land caused by incendiary kites and balloons launched from Gaza into Israel during the Great Return March. And they argue they're liable because the US campaign expressed support on social media for Palestinians' right to protest and demand their right to return without being shot at by Israel. The other reason they claim they're liable is because they served for a time as the US fiscal sponsor for the Boycott National Committee, which is a coalition of Palestinian civil society that supports global BDS campaigns. And they claimed that because one of the BNC's many members is another coalition that's made up of all Palestinian political parties, and one of those is Hamas, that of course that makes the US campaign liable for material support to terrorism. So it's, you know, a completely absurd case, which the court found in dismissing it for failing to state a claim, even assuming everything they said was true. The court said there's simply no plausible allegation that the US campaign caused damage to plaintiffs' land in this way. So the JNF has appealed to the DC circuit, and we're waiting for an argument date on that. And, you know, litigation is bad enough. And like the label of anti-Semitism, the terrorism label has the power to chill speech and funders in unique ways, which I think Meera might address later on. So just a couple more cases. These are just representative. You know, in 2018, after years of grassroots advocacy, Airbnb announced that it would delist 200 properties in Israeli settlements in the occupied West Bank so that people wouldn't be able to post them on Airbnb because settlements are in violation of international law. So Airbnb was widely attacked, and the governors of Florida and Texas announced that they were adding Airbnb to anti-boycott blacklists, and which would prevent state investments or contracts with them. And Brian will talk more about those anti-BDS laws. But attorneys associated with Shrat Hadin, which is the Israeli Law Center, sued Airbnb on behalf of US settlers in Israel, claiming that Airbnb was discriminating against Jews and or Israelis under the Federal Fair Housing Act because only Israeli Jews live in settlements. Another completely absurd argument. So CCR moved to intervene on behalf of Palestinians and Palestinian entities who own the land or simply can't enter the settlements because they're Palestinian, to bring counterclaims against the settlers for trespass and unjust enrichment and for displacement and persecution under international law. Unfortunately, Airbnb capitulated and settled the case, announcing it would reverse its position and allow listings in Israeli settlements again. We also seen, you know, last year, Ben & Jerry announced it wouldn't renew its licensing agreement in Israel, and stating it was inconsistent with their values to have products sold in the occupied Palestinian territory. And Ben & Jerry's was subject to widespread attacks. And so at least 5 states, I think, have announced divestment from the parent company, Unilever, and the Brandeis Center recently filed a lawsuit against them and Ben & Jerry's on behalf of the Israeli manufacturer and distributor, asking a federal court to deem the termination of the contract illegal. So there are more, but I will leave it at those cases. They all target boycotts or perceived boycotts for equality and respect for international law. And even though they're meritless, they're a distraction and a nuisance, and worst of all, they're chilling, and that's their purpose, to punish the targets and deter anyone else. They're, you know, as Yousef was talking about, these attacks are an extension of Israel's oppression of Palestinians living under occupation, under siege, under apartheid, and under attack. And when there's no defense, the tactic is to try to stop the debate by attacking the opponent, attacking the people actually advocating for rights and freedom. So the most important thing is not to be silenced. We can use these opportunities to discuss the real issues, to change the narrative and educate more and more people, and to build the movement and power, and to put a spotlight on Israel's repression and demand that Israel stop displacing and detaining and killing Palestinians and stop constructing new Jewish-only settlements. And we also need to increase pressure on the US government to end unconditional aid and support to Israel, or nothing will change. Thank you.
Thank you, Maria, for this very eye-opening, some very concrete examples of the use of law to silence Palestine advocacy and activism as an extension of Israeli repressive policies. And, you know, I think we'll have a lot of questions coming up, and we'll come back to that during the discussion. Just a reminder to our audience, feel free to send in your question at any time through the Q&A platform or by email to events@arabcenterdc.org. Next up, we have Brian, who will focus a little bit more on the anti-boycott legislation at state and national levels, and maybe how these have been challenged in courts. And maybe if you could, if you have a little bit of time, to touch on the role of media and censorship and free speech at the end. Brian, go ahead.
Thanks so much, Tamara. It's a pleasure to be here speaking with you all this morning together with my distinguished co-panelists. The ACLU is a nonprofit, nonpartisan organization dedicated to defending civil rights and civil liberties. We are a domestic civil rights and civil liberties organization, so we do not generally take a position on international human rights issues and boycott campaigns like the Palestinian BDS movement. We are, however, vigorously committed to defending free expression and the right to dissent, which has been central to our mission since 1920. And it is in that capacity that we have weighed in against many of the censorship efforts targeted at Palestinian rights activists, including efforts to suppress BDS and other boycott of Israel campaigns. So I'll start off by talking about the federal legislation in this area. And I think the main piece of federal legislation to focus on is the Israel Anti-Boycott Act. This is a bill that has been introduced in every Congress since 2017, often with bipartisan support, which would make it a felony for any US person to participate in boycotts of Israel or Israel's West Bank settlements if the boycott is called for by international governmental organizations like the UN Human Rights Council. And critically, the bill would also make it a crime to share information with the UN Human Rights Council about whether a company is operating in Israel's West Bank settlements. And I think the goal of that is basically to prevent the UN from identifying companies that are participating in human rights abuses by operating in the Israeli settlements in the West Bank. As I mentioned, this bill would make it a federal felony. The original version of the bill actually made it a felony with potentially 20 years of jail time for any US person to participate in these boycotts if they're called for by the UN. Fortunately, the bill has not advanced, has not been able to be enacted in the Congress. But if Republicans take back control of Congress next year, I think there's a very strong likelihood that we will see that bill advancing once again. At the state level, more than 30 states have passed laws or executive orders seeking to suppress boycotts of Israel. Their restrictions typically take two forms. On the one hand, many of these state laws require that the states divest their assets, for example, their pension funds, from any company that's found to be participating in a boycott of Israel or the settlements. And for this purpose, many of the states, including, for example, New York, have compiled blacklists of companies that they believe are participating in these BDS campaigns. On the other hand, many of these state laws also require government contractors to certify that they are not participating in boycotts of Israel or the settlements in order to get or to keep their government contracts. And actually, in the past few years, we've seen these laws expand out even beyond boycotts of Israel to encompass boycotts on other types of issues, whether it's boycotts of firearm manufacturers, fossil fuel companies, mining companies, timber interests, agriculture interests. So we can see on the conservative side of the aisle, the idea that this anti-boycott measure can be used to protect all sorts of different interests, even outside the Israel debate. And so it's becoming a template for censorship on a much broader array of issues. Our position at the ACLU since the Israel Anti-Boycott Act was first introduced, and even when many of these state laws were being introduced as early as 2015, is that these laws violate the First Amendment right to boycott. And I think in discussing this right, it's important to start with history behind it. There is a very long tradition of using boycotts as a protest tactic, both globally and in the United States. And I think, in fact, the American revolutionaries can be credited with really expanding the use of boycotts as a specifically political tool. During the American Revolution, Sons of Liberty and other revolutionary aligned groups entered into non-consumption and non-importation agreements targeting British goods. This is, of course, the famous Boston Tea Party, where the colonists dumped the British tea into the harbor in order to protest repressive legislation from Parliament, like the Stamp Act or the Tea Act. And historians have credited the participation in these boycott movements with the building of a national solidarity. It was actually some of the first votes taken by the Continental Congress were on these boycott measures. It created a uniquely American identity, and it really provided a major tool for the colonists to protest what they viewed as oppressive actions from the Parliament. Even going beyond the American Revolution, many of the first presidents of the United States and other significant political leaders like Alexander Hamilton participated in abolitionist boycott campaigns targeting slave-made goods from the American South. And boycotts of slave-made goods were important to the abolitionist movement right up through the Civil War. Moving further on into the modern era, of course, boycotts were central to the civil rights movement. And I think the Montgomery bus boycott is often seen as one of the landmark political protests in US history. And that's, when Black citizens in Alabama said, we're not going to give our goods and give our time to the Montgomery bus system if the Montgomery bus system is going to tell us where to sit. Similarly, the boycotts, as Yousef, I think, already mentioned, were essential to the campaign to convince South Africa to give up its apartheid regime, and that is in fact the inspiration for the Palestinian boycott movement. Even today, of course, boycotts are a central feature of American politics. They take place across the political spectrum. On the conservative side of the aisle, for example, there were boycotts of French-made goods to protest France's opposition to the Iraq War. I'm sure many of us remember the Freedom Fries. Similarly, Ted Cruz, for example, said that when Nike featured Colin Kaepernick in many of their advertising campaigns, Ted Cruz, who was opposed to this, said that Nike had exercised their First Amendment rights, so he was determined to exercise his, and that he was henceforth going to be participating in a boycott of Nike products. So I do think that there is actually widespread recognition once you step outside of the Israel-Palestine debate that boycotts are an essential protest tool, and they're a fundamental part of free expression in the United States. Now let's get to the legal issue here. In NAACP versus Claiborne Hardware, which is a case from 1982, the Supreme Court unanimously held that the First Amendment protects the right to participate in politically motivated consumer boycotts. That case concerned a civil rights boycott of white-owned businesses in Port Gibson, Mississippi, to protest ongoing segregation and inequality in that community. The boycotted companies sued the NAACP and all of the boycott participants for tortious interference with business relations. And the state Supreme Court held the boycott participants collectively liable for all business losses resulting from the boycott. The US Supreme Court unanimously reversed, holding that the boycott was a form of political protest resting on the highest rung of the hierarchy of First Amendment values, and that the power of the government to regulate economic activity could not justify the suppression of a politically motivated consumer boycott. So these state anti-boycott laws, from our perspective, completely infringe on the First Amendment right to participate in politically motivated consumer boycotts of goods and services, either from companies that are operating with the Israeli government or that are operating in Israeli settlements in the West Bank. One argument we often see in defense of these Israel anti-boycott laws is that they don't outlaw boycotts completely yet, although I think, at least with regards to the Israel Anti-Boycott Act in Congress, it does outlaw participation in certain kinds of boycotts completely. But at least with regards to the state bills, the government often says, we're not making it a crime to participate in these boycotts. We're merely boycotting the boycotters. And why doesn't the state government have that right to express its political views on this issue? But of course, the First Amendment protects the rights of the people, not the rights of the government. And it's been well established since the McCarthy era that the government cannot require public employees or government contractors to disavow participation in protected expression as a condition of getting or keeping a government job. And the foundational cases in that era were, when state and federal governments were essentially requiring public employees, university professors, contractors, other employees, to sign loyalty oaths, guaranteeing that they were not members of subversive groups or engaged in subversive political advocacy on their own private time and dime. And what the Supreme Court said is that although the government has some power to control your speech while you're at work for the government, what it can't do is use its economic leverage over private citizens to control their private expression on their own time and dime. So together with the Council on American Islamic Relations, the ACLU has filed lawsuits I think there's lawsuits have been filed by the ACLU or CARE in 6 states, Kansas, Arizona, Texas, Arkansas, Georgia, and Maryland. The plaintiffs of these cases come from all walks of life. For example, Esther Kuntz, the plaintiff in our Kansas case, was a substitute math teacher who participates in a boycott of Israel. And in order to teach math classes in Kansas, she was required to sign a form saying that she wouldn't boycott Israel or the settlements. Similarly, Mick Jordahl is a lawyer, provides legal services to the state of Arizona Department of Corrections. In order to continue providing those services, he was required to say that he wouldn't participate in a boycott of companies like Hewlett-Packard because of their business relationships with the Israeli government. In Arkansas, we represent the Arkansas Times, which is a community newspaper. They have advertising contracts with a local technical college. In order to continue publishing those advertisements and to keep their advertising contracts, they were required to certify that they don't participate in a boycott of Israel or the settlements. And then in cases like Texas, you have Bahia Mawi, CARE's client, who is a speech pathologist. We represented college students who wanted to judge high school debate tournaments, journalists working for NPR affiliates affiliated with the local university. All of them were required to sign these unconstitutional anti-boycott forms as a condition of keeping their government jobs. And we maintain that that violated the First Amendment. I'll just add one more example there, although it didn't result in a lawsuit. In Texas, after Hurricane Harvey, a Palestinian man who wanted to obtain hurricane relief funds from the government was initially required to sign a form promising that he wouldn't boycott Israel or the settlements in order to get funds to help rebuild his home. Fortunately, after public outcry, in that instance, the government retracted the certification demand. And in fact, when we've brought these lawsuits in federal court, the vast majority of the time, we've won. The federal courts have concluded that these laws unconstitutionally require our clients to disavow participation in protected political protests in order to keep a government job, and that the government has no legitimate interest in suppressing that expression. One of the arguments we often see here, as Yousef alluded to, is the government saying, well, these are actually discriminatory boycotts. And so our interest in preventing discrimination is a sufficient justification for removing the First Amendment protection from this political protest. I think the really important thing to understand here is that the First Amendment does not extend its protections based on viewpoint. And so the First Amendment protects racist speech just as much as speech advocating equality. And one of the reasons for that is to remove those debates from the field of First Amendment expression. So people can argue until the cows come home about whether these boycotts are discriminatory or not. But at the end of the day, political protest and expression can't be censored based on its viewpoint, even if the court were to find that viewpoint offensive. I think the other really essential thing to point out with regards to these arguments is that these are not framed as anti-discrimination laws. These are not laws that say people cannot participate in discriminatory refusals to deal generally. These are laws that target politically motivated boycotts of a single country. And in doing so, I think they make it clear that the government's interest is not in preventing discrimination generally, but it's rather in suppressing one side of a political debate, and that's why they violate the First Amendment. Now, as I mentioned, most of the time we've been successful, but there was one case in particular where we were not successful in the district court. That was in Arkansas. There, the federal court held, in fact, that there is no First Amendment right to boycott. And I think the implications of that ruling are astoundingly broad. It would mean not only that the federal government could pass the Israel Anti-Boycott Act, but in fact, that any government in the United States could make it a crime to participate in disfavored boycott campaigns, whether that's a campaign like the Montgomery Civil Rights Boycott, or as a campaign like the BDS boycott. And so that's an astounding power grab by the government to essentially decide whether consumers can make these politically motivated choices about whether to participate in a boycott or not. We ended up appealing that decision to the United States Court of Appeals for the Eighth Circuit. The court eventually held that the Arkansas law does violate the First Amendment, not necessarily because it prohibits participation in boycott campaigns directly. The court decided not to reach that issue, but it held that the law also suppresses and chills speech and association supporting a boycott. Because of the way the law was written, it is very plausible that the law could be applied to someone, for example, picketing outside a Best Buy, saying, don't buy Hewlett-Packard printers. Hewlett-Packard has contracts with the Israeli Defense Forces. And on that ground, the Eighth Circuit said that the law violated the First Amendment, and so it didn't need to address the broader question about whether the First Amendment protects boycotts or not. Since that happened, the full Eighth Circuit, the en banc Eighth Circuit, all 11 active judges have voted to rehear the case. The argument took place last September, and we're awaiting a decision from the Eighth Circuit now. And eventually, I think one of these cases, frankly, is going to go up to the Supreme Court, just because we've seen such a proliferation of laws in this area. And now the laws are expanding outside of this discrete issue area of Israel and Palestine and expanding into other sorts of boycott movements. And so sooner or later, I think the Supreme Court is going to recognize that it needs to step in and make clear, I think, what it already said clearly in Claiborne, which is that the First Amendment protects this activity. Touching just briefly on questions of media censorship, I think what I'll focus on have been concerning decisions by platforms like Zoom, which we're all using here today, to unilaterally withdraw service from events if it concludes that hosting a particular speaker would constitute material support for terrorism. And so one of the main examples here is when Zoom effectively shut down an event at San Francisco State University because the event was, concerned gender and resistance narratives, featured Layla Khalid. And Zoom concluded that even having Layla Khalid talk at all at this event, regardless of what she was going to say, would amount to material support for terrorism. And I think it's important to point out here that no court has ever upheld such a broad reading of the material support statute to preclude academic discussions of this nature. And if the government were to attempt such a prosecution, it would almost certainly violate the First Amendment. But I think it's very troubling at a time when we're all increasingly relying on these teleconferencing platforms to communicate, to have academic discussions, that the platforms themselves are making these unilateral censorship decisions about which speakers can participate in an academic conference. And so I think that has been the theme underlying all of this, which is centralized decision makers, whether it's in the federal government, the state governments, or companies like Zoom, making decisions about which forms of protest are legitimate or not. And that's a question that the First Amendment takes off the table, at least with respect to government actors. Thank you.
Thank you, Brian, for this excellent review and update on the legislation issues, both state and federal, and the cases that you've been working on. Next, we have Meera, who will focus on academia, particularly repression on college campuses, threats to academic freedom, and false accusations and administrative actions against activists. Meera, you have 12 minutes.
Thanks, Tamara, and thanks to the Arab Center for this invitation, and to my co-panelists and to the audience for being here. So Palestine Legal, we are a legal advocacy organization whose mission is to bolster the grassroots movement for Palestinian rights here in the US. We provide legal advice, know your rights trainings, advocacy, and litigation support to college students, activists, and others who are experiencing backlash for their advocacy and support of Palestinian rights. We also document and track the tactics that are being used to silence advocates. And so, I think, other panelists have mentioned, I just want to start with some sort of broader context and hone in on a few of the tactics that we've documented. There is a growing Palestine solidarity movement here in the US. It is student-led, it's diverse, it's dynamic, and it's increasingly interconnected with other racial justice struggles here, and it's filtering up from the grassroots. These calls for freedom, equality, and justice for Palestinians have been met with efforts to censor, chill, and punish. And Palestine Legal has documented the widespread censorship and harassment of Palestine activists over the years. Since 2014, we've documented more than 2,000 incidents of suppression, which is just the tip of the iceberg because it is what is reported to us. And what we've seen in these incidents, across these incidents, is that advocates who speak out for Palestinian rights are routinely harassed, surveilled, threatened, falsely accused, censored, punished. And so, you've heard now about the harassing lawsuits and the legislation targeting advocacy for Palestinian rights from some of the other panelists. And I'd like to just focus on a couple of the other common tactics and the context that we've seen. I'm going to start with false accusations. False accusations of anti-Semitism and support for terrorism are the most common tactic that we've documented. And they lay the foundation for many other forms of repression and harassment. They rely on anti-Muslim, anti-Arab, anti-Palestinian tropes. And these smear campaigns falsely portray activists who support Palestinian freedom as anti-Semitic or, as supporters of terrorism. More than 60% of the incidents that we've responded to involve these kinds of false accusations. So what does that look like? It often involves online blacklists and other doxing sites that collect personal information about Palestinian rights advocates and falsely accuse them of anti-Semitism or terrorism for because of their support for Palestinian rights. And these smear campaigns often generate sort of cruel cyber harassment campaigns. They can involve astroturfed petitions. They can also involve tagging law enforcement agencies or employers to pressure them to punish these advocates for Palestinian rights. There are a number of different players here. In this space, Canary Mission is perhaps one that many have heard of, stopantisemitism.org, BDS report. Until recently, there was also, act.il, which is a mobile phone app that was funded in part by the Israeli government that rewarded users who sent these pre-drafted complaints that included false accusations. And what these campaigns do and are intended to do is to really chill debate and to justify punitive action against advocates for Palestinian rights. While schools or employers face pressure to punish and investigate and question advocates, the advocates themselves receive this sort of mass onslaught of threatening, violent, and racist messages. And so, I think what's happened in recent years, and I think this connects back to what both Brian and Yousef had mentioned, is in an effort to add legitimacy to these false anti-Semitism accusations, Israel advocacy groups have really lobbied for legislation and policies that would codify these smears into law by redefining anti-Semitism to encompass nearly all criticism of Israel. These redefinition efforts have come under different names and iterations, but the most prevalent is probably the International Holocaust Remembrance Alliance definition, or IRA definition. And this definition, it blurs the lines between anti-Semitism and criticism of Israel, and it will result in the censorship of constitutionally protected political speech. This is not a theoretical concern or a future abstract concern, but it's one that we know because it's how it's been how Israel advocates have wielded this definition even before it's been codified into law. At this stage, at least Florida, South Carolina, Texas, and Arizona have laws adopting some version of this definition. And in December of 2019, Donald Trump signed an executive order directing government agencies to consider this distorted definition when investigating discrimination allegations, which led to a flurry of complaints filed against universities for permitting Palestine advocacy on campus. Many of those are still pending. I'm going to stop on the sort of false accusations piece, but I just want to say in terms of legislation, we have more resources on our website where we're tracking and analyzing these bills, as well as the anti-boycott bills that are targeting advocacy for Palestinian rights here in the US. And I want to turn now to the campus context. And really, I want to probably give more examples, but I think important to set some context here that, in last May, as part of the Unity uprising, we saw, greater numbers of people from all different sectors speaking out in support of Palestinian rights. But college campuses continue to be a significant context for Palestine solidarity, as well as the backlash to it. Nearly 60% of the incidents that Palestine Legal responded to in 2021 targeted students and scholars at 81 different campuses across the country. And the numbers evidence, I think, the importance and vibrancy of this space for organizing in support of Palestinian rights. I think one good example of this, Tufts University's Students for Justice in Palestine, SJP, was given a collaboration award in 2020 for their Deadly Exchange campaign, which was an effort to end collaboration between US police and Tufts police in particular with Israeli military and security forces. More than 40 other student groups eventually joined this campaign, representing a wide cross-section of the student body. And the subsequent referendum on the issue passed with overwhelming support and participation. And so, I think that that's an example of sort of what the vibrancy and organizing on college campuses looks like. In terms of the repression, in turn, often, it can take the form of sort of microaggressions, perhaps, or bureaucratic barriers, which, could include denying or delaying funding and room reservations for student group events, requiring balance of Palestine-related programs with pro-Israel programming, or requiring quote-unquote neutral moderators, or pressuring advocates to change their speakers or issue disclaimers distancing themselves from the school, or imposing police presence on events or charging for extra security. But we've also seen, a more egregious threats on college campuses, ranging from censorship, investigations into students and faculty for their Palestine advocacy, and threats to academic freedom. So earlier this month, CUNY's John Jay College canceled a student-organized conference commemorating the Nakba. The school claimed that organizers had failed to follow proper procedures and also cited to a lack of adequate security. But the alleged procedural irregularities were flagged only days before the event. And even after the organizers acceded to the school's additional security demands, the school refused to, still canceled the event, which I think suggests that the decision to cancel was really about the content and the viewpoint of the conference, which would be unconstitutional. And we've seen this over and over, where procedural excuses have been weaponized against Palestine advocates as an excuse to justify censorship of campus advocacy. Another sort of similar example, last year, Butler University canceled a talk with Dr. Angela Davis just 3 days before the event was scheduled to take place, following complaints over Davis's support for Palestinian freedom. The university blamed the student government for supposedly failing, again, to follow proper procedures. And it was only after pressure from Palestinian students and their allies that the university eventually reinstated the event. Another sort of example, and I'm going to offer a few of these that kind of give you a range of the different types of situations we've seen at St. John's University, also in New York, at their virtual commencement ceremony last year. The school censored a Palestinian doctoral student, deleting, free Palestine from her graduation slide and claiming it was, violated a policy against defamatory, libelous, obscene, immoral, or fraudulent behavior and conduct. So after the student complained, the school eventually did restore the language to her slide, but this was only, days after the ceremony had already taken place. So this, and finally, just, in terms of course content, scholarship, we've also seen Israel advocacy groups launch smear campaigns based on instructors' viewpoints. And at UNC Chapel Hill, a member of Congress and an Israeli diplomat met with school officials to pressure them to cancel a course on the conflict over Israel-Palestine. And I think, it's important. There's so many more examples I can pull from, but I want to, just note that, the unique impact, I think, of the repression on Palestinians in particular, and Palestinian students, faculty, and employees have faced, amplified discrimination and harassment on campus and other contexts, often being singled out from their allies for bullying and false accusations. So at Florida State University in June 2020, Ahmed Omar Daraldik was the first Palestinian elected as president of the FSU Student Senate. Following his election, he became the target of a vicious cyberbullying and harassment campaign aimed at removing him from his position and attacking him for expressing his outrage over Israel's treatment of Palestinians. Even state lawmakers joined into this chorus of attacks, contributing to an anti-Palestinian environment. And Palestine Legal has stepped in to support Ahmed in filing a Title VI complaint with the Department of Education's Office for Civil Rights over this anti-Palestinian environment at Florida State University. Another example from George Washington, also from last year, a university office that offered trauma counseling and support to the GW community, offered a healing space for Palestinian community members in the midst of the Unity Uprising and in the midst of the forced evictions and military attacks on Gaza last May and June that killed hundreds of Palestinians and devastated infrastructure there. The office had previously offered these types of healing spaces for Asian students, Black students, and other community members impacted by racism or state violence during that same year. But within 24 hours of advertising the support service on Instagram, GW administrators directed the office to cancel the event and remove the post. So, the result here, Palestinians were denied access to trauma services at a time when relatives and community members were under attack, denied an equal access to university services that other students, had benefited from, which is arguably a form of discrimination. And Palestine Legal has filed a complaint under the DC Human Rights Act that is still pending. I want to give one more example, I think, if I have just a minute. The City University of New York School of Law, CUNY Law, a law student there, Nardine Kiswani, is a well-known activist for Palestinian freedom and a frequent target of Zionist groups who've deployed, vicious smear campaigns and false accusations of anti-Semitism to vilify her. Since she started at CUNY Law in fall 2019, anti-Palestinian students and groups like StopAntisemitism.org and BDS Report have targeted Nardine using these cyberbullying tactics. And in September of 2020, she faced a sort of a character assassination campaign after she posted an old video of herself waving a lighter while criticizing a friend for wearing a t-shirt promoting the Israeli military. And a vilification campaign based on this incident followed and was bolstered in part by Act.il, the Israeli government affiliated app, which rewarded users if they sent pre-scripted emails to the CUNY administration that falsely claimed that Nardine had threatened a Zionist fellow student and called for her to be punished. So CUNY Law initially released statements condemning Nardine, which were later deleted, exposing her to even further racist and violent sort of messages and vitriol online. And in June 2021, after months of student pressure, CUNY Law finally issued a statement in support of Nardine, saying that the law school, quote, supports the free speech rights of Nardine Kiswani, other Palestinian students, and their Jewish and non-Jewish allies who have been vilified for their activism, end quote. And so I think just an example that also shows when there's mobilization and pushback against this kind of repressive backlash, that there are important opportunities there as well to support activists in their expression in support of Palestinian rights. So I want to just circle back really quickly to what Yousef had started with in terms of where is this coming from, just to connect a few more dots here, because he mentioned the Ministry of Strategic Affairs, which is an Israeli ministry that has identified boycotts and BDS in particular as an existential threat, devoting hundreds of millions of dollars to fighting it. But I think it's also important to highlight that pro-Israel groups in the US are working closely with right-wing groups here, and that are fueling suppression and dissent, sort of attacks on dissent across different social justice movements. And I want to mention in particular here, sort of connected to the legislative piece, the role of ALEC, the American Legislative Exchange Council. And this is an organization that brings together conservative legislators and corporate lobbyists to develop and disseminate model legislation that safeguards corporate power and white supremacy. It's responsible for sort of pushing bills such as stand your ground laws and voter ID laws that have targeted communities of color in particular. And they've been, part of the process of developing and advocating legislation targeting advocacy for Palestinian rights, including anti-boycott bills and these anti-Semitism redefinition bills as well. I think it's important to note the role of these right-wing groups and what it signals about the sort of anti-progressive nature of the anti-Palestinian repression we're seeing across these different sectors. And I think it kind of shows that these anti-Palestinian efforts are of a piece with other regressive and racist efforts to quash dissent here. And I think you see this most clearly in the legislative context where, as Brian mentioned, the anti-BDS bills have become a template for punishing other justice movements. But I think it's also significant in other areas beyond legislation as well, in terms of the tactics of repression that we're seeing and that are common, I think, to many justice movements here. And I think it's a sign that the repression, it's an indication, right? The repression is not unique to Palestinian rights advocacy. It's clearly part of a broader context where there's a crackdown on protesters, human rights defenders, and those dissenting from the status quo. But I think it also underscores the importance of cross-movement solidarity to address these repressive efforts together, and the need to organize and build relationships across communities and movements. Because ultimately, we see that the tide is turning. We see an increased awareness of and opposition to Israel's treatment of Palestinians. And even in the face of these repressive measures, we see that SJP chapters are growing, BDS wins accumulate, and they are filtering up from the grassroots to mainstream media and decision makers. So I'm going to stop here. I just want to say, though, please don't hesitate to reach out to Palestine Legal if you need legal support related to your advocacy for Palestinian rights. We are happy to be your resource, and I look forward to the questions. Thanks.
Thank you so much, Meera, for this, and thanks to all of the panelists for these excellent remarks. We do have a few questions coming in. Before that, just a quick reminder, you can send in your questions here on Zoom or by email to events@arabcenterdc.org. I want to start where Meera left off, and just a kind of a quick context, if you will, and maybe we'll start with Yousef on that, and anybody else who would like to answer. Meera mentioned that there's a broader context of these groups and their repressive efforts, and Brian alluded to some extent that the boycott idea is accepted generally in other contexts, and there's some sort of an exception for the Palestine-Israel debate. And we've heard about all of these cases and lawsuits being meritless, absurd, unconstitutional, and in most cases, violation of the First Amendment rights. So what makes these cases persistent? What makes this continue to happen in the US? And is it a unique situation for the Palestine-Israel discussion? Is it an exception? Yousef, if you'd like to start, and then we can see who else wants to answer.
Yeah, I mean, I think I would say that one of the things that makes them so consistent is that apartheid is a very difficult product to sell. It's a very expensive product to sell. And frankly, if it was easy to convince people about this, the supporters of Israeli policy would be welcoming debate instead of attempting to shut it down. But it's become clear that their policies are harder and harder and harder to defend over time. And so they prefer instead to not have the debate and try to prevent the debate from happening altogether, especially when it comes to any accountability for their treatment of Palestinians. And so I think that's the main driving force here. Is it unique? Look, I think there, and others can speak to this as well. I think there are some things about what we're seeing today that is unique, but also some things that are not entirely unique. There's a great book by Ron Nixon called Selling Apartheid, which is entirely about the South African apartheid regime's efforts to combat the anti-apartheid movement internationally. And many of the themes, practices, policies that we see practiced by the Israeli government and their supporters today are echoed from that moment. At the same time, I do think there are things that are unique about what we are seeing today, and a lot has to do with the kind of capacity and relationships that the Israeli government can bring to this effort. That's not really comparable to what a lot of other state actors can bring. If you look, for example, at the use of high-tech surveillance tools that the Israeli government has been a global leader in proliferating to regimes around the world that target dissenters. These are the kind of tools and practices that not a whole lot of state actors have. And the Israeli government is able to bring them to bear in ways that we probably are not even fully aware of. So I think there's commonalities here, but there are also some things that make the cases that we're looking at quite unique.
Okay, we have a few questions. I'll do 3 at a time maybe, and we'll see who would like to answer them. There are a couple of questions at the beginning. One from Ziad Boubaker. He asks, what can people do to protect themselves from retaliation for doing their constitutional right and supporting the Palestinian cause? And I think many of you are involved in some of these cases to support activists. So if you want to talk about that a little bit. Rose Esper is asking, what strategies and tactics can advocates use to effectively counter Zionist efforts to repress criticism of their policies? What have proved to be effective, I guess, would be maybe an addition to that. And then one more question. Have similar tactics to silence Palestinian rights advocates groups, including lawsuits and discrimination on hate speech grounds, have they been used against Jewish American dissident groups such as Jewish Voice for Peace, and if not now? And how effective have they been in these cases? So I think we'll do this round of questions and we'll come back to another round. Maybe we can start with Maria, and then we'll
Sure. And then Meera might want to add too. I mean, as far as what to do to protect yourself, Meera mentioned Palestine Legal has Know Your Rights manuals. You can, be prepared in advance, and you can also obviously contact Palestine Legal or CCR when anything is happening, or if you're concerned about anything happening. As far as strategies, general strategies to counter repression, I mean, I think it really depends on the circumstances, but it's important to expose it as part of widespread repression, educate the targets, let them know they're in good company, let them know what Israel is doing. I think it's important to really use it as an opportunity and stay on the offensive. But of course, depending on what's happening, there's other tactics like whether to ignore it so as not to make it a bigger deal than it is, or whether to address it head on. And those are things that really depend. As far as similar tactics against Jewish American groups, I can't think of any cases, but certainly other silencing tactics, many of which Meera mentioned, are used against everyone. But that's not to say that Palestinians and people of color are not targeted even more and in different ways as well.
Yeah, thanks. Can I
if you want to add, and then we'll go to Yousef.
Thanks. Yeah, I mean, I think everything that Maria said, yes, and also just to bring it back, I think, to what Maria and others said earlier, is that to remember that this is, these repression tactics are a form of distraction, and intended to chill and to sort of draw attention away from what is happening to Palestinians on the ground. And, and I think it's important to remember that and to keep focus on that aspect, right? And to not let the repression tactics themselves distract you from your advocacy and support of Palestinian rights, and to know that, there are, protections here, both in terms of the law, I think, but also in terms of organizing and community support, and the importance of sort of reaching out to others in that process as well. And of course, if you have questions or if you face backlash, to reach out to Palestine Legal or CCR for any support that you might need. Just on sort of Jewish organizations, I do want to mention, I think, again, like, no lawsuits that I'm aware of necessarily, but I think definitely have been targeted. And I think most recently we've seen that in, a recent speech by Jonathan Greenblatt from the Anti-Defamation League, the ADL, which, singled out a number of different organizations, Palestinian organizations, but also Jewish Voice for Peace, and really, explicitly tried to make this connection between, criticism of Israel or anti-Zionism and anti-Semitism. And really, I think it's so problematically conflating those two issues, and doing so, by a sort of mainstream, considered to be a civil liberties organization that, if you look more closely, and it has been documented by the work of, a coalition of groups under the Drop the ADL heading, and I would just urge people to check out droptheadl.org for more information on this, but, to look at ADL's history of undermining communities of color, and sort of being part of that process. So sort of nothing new here, but I think just important to sort of flag this most recent development and the targeting of Jewish Voice for Peace in particular.
Thank you. Yousef, did you want to add something?
Yeah, just very briefly, they're outside of the United States. We have seen instances in Europe in particular where, for example, a Jewish group, very similar to Jewish Voices for Peace in Germany, had its bank account shut down because of its support for BDS. And this is a move that was, of course, welcomed and cheered on by Israeli government officials. If you can imagine Israeli officials cheering on the repression of Jewish groups by the German government, this is something that is in fact taking place today. And we did not say a whole lot in this conversation about deplatforming, which is another one of these tactics we see, where whether it's financial institutions or social media platforms come under pressure to close the accounts, whether it's financial accounts or social media accounts of people who are being targets of these repressive efforts, for example, for supporting the BDS campaign. So I think there's a wide range of people who are being targeted here, even though overwhelmingly it is Palestinians first and foremost.
Thank you, Yousef, and we'll do another round of questions. A question from Hassan Ashawaf. He asks, do state anti-BDS laws impede the federal government's exclusive power to conduct foreign policy, or are they otherwise preempted by federal law? And I think that might be a question for Brian. Another question from Wolf Elrickman. What about companies such as PayPal and MasterCard not processing financial transactions of quote unquote terrorist groups? Question from Ian Drummond. For Brian, how confident are you the Supreme Court will rule the right way if one of these cases comes before it, especially right now in the climate of hyper-partisan conservative justices and the overturning of Roe v. Wade? I will do these three questions, starting with Brian, and then we'll take another round. Brian?
Sure. So I'll start with the question about the Supreme Court. And I'll say this is a Supreme Court that I disagree with very, very strongly on many issues, but one area where there's been a surprising amount of relatively strong bipartisan consensus, even on this very conservative Supreme Court, is robust protection for First Amendment freedoms. And so while recognizing, as Yousef was saying, that there often is a Palestinian exception on First Amendment issues, I think And I hope that the Supreme Court, when it's confronted with this question, will recognize that this question is not just about Israel and Palestine, it's about the government's power to regulate this, distinctly American form of protest activity, and that it will do what it already did 40 years ago and hold unanimously, hopefully, but if not at least by a majority, that the First Amendment still protects the right to boycott. So I'm sitting where I am today, I'm still optimistic that there is robust support for First Amendment freedoms at the Supreme Court, despite backsliding in other areas. Turning briefly to the preemption question, so in general, states don't, I think, have a legitimate interest in conducting foreign policy. And so to the extent states try to defend these anti-boycott laws by saying, well, we really love Israel and we just want to show how much we love Israel and we want to support our strategic ally, Israel, that's not a really legitimate government interest for the state to be asserting. That's an interest for the federal government to be asserting. Whether the states can still do that, right, and say, well, putting that aside, can we have a law about something that potentially impact foreign policy? I mean, there have been other types of laws that states pass, regulating how people protest outside of foreign embassies, for example. I think the DC government passed a law about that. I don't think passing those laws necessarily presents a federalism problem, even if the state doesn't have a legitimate foreign policy interest. There might be a statutory preemption problem, and here, the main issue is a law from the 70s known as the Export Administration Act. This was a law that essentially makes it illegal to enter into an agreement with a foreign country to participate in a boycott of a country friendly to the United States. And the purpose of that statute was really that the Arab League was requiring US companies that wanted to operate in the Arab League countries to agree that they would not operate in Israel. Right? So if you were Coke and you wanted to operate in the Arab League countries, you had to promise that you wouldn't sell any products in Israel. And so the government essentially passed the Export Administration Act, I think, with the goal of saying we don't want foreign governments kind of strong arming US companies into taking political positions. And so we're going to collectively bar US companies from entering into these agreements with foreign governments. And so in order to avoid preemption issues with that statute, you see many of the state laws say that none of the anti-boycott activities regulated by none of the boycott activities regulated by the state law are subject to regulation if they're covered by the federal law. So they basically kind of divide it up and make sure that there's not a preemption issue. The Export Administration Act is sometimes cited as a justification for why it's perfectly okay to have the Israel Anti-Boycott Act. But I think that equivalence is really specious because the whole point of the Export Administration Act was to prevent US companies from entering into agreements with foreign governments about their business activities in those foreign countries. And so it was designed to protect US companies from being exploited in these ways. What you have instead here with the Israel Anti-Boycott Act and with the state laws is US domestic governments trying to dictate US companies purely political decisions, not an agreement entered into with a foreign government in exchange for contracts or rights to operate or any sorts of economic consideration, but a purely politically motivated decision, a conscience-based decision not to support a regime that they find oppressive. And that is very, very different from the regime that was established by the Export Administration Act. And so that's why I think these new laws present an entirely different issue.
Thank you, Brian. And we'll come back if anyone wants to address the question about PayPal and MasterCard. Yousef mentioned a little bit the idea of deplatforming, and we'll come back to that. I just want to get through a few more questions as we're getting close to the end of the webinar here. The question from John Mason: how is BDS technically or otherwise any more political than other boycotts, such as civil rights boycotts? Is any or every anti-Israel protest or boycott definable as anti-Semitic? Can't this illogical notion be debunked once and for all? We have a question from Martha Gutenberg. She's saying they're doing some investigation as amateurs, she says, of US-based 501c3 organizations that present themselves as charities supporting Israel, but in fact support settler violence. If you have any suggestions or recommendations or resources for them. And there is a question from Shireen Zarqa-Lederman. Is there any legal recourse or class action lawsuit against any social media platforms that have been silencing Palestinian influencers? They're not government entities, private sector companies. or in the case of, just not only silencing, but cyberbullying, slander, defamation, and so on. And I think that's all we can do for now. We'll take those questions and maybe give each one of you a minute or a minute and a half to answer any of those questions that you feel strongly about and give your concluding remarks. And we can start with Yousef, and we'll go the same order that we did at the beginning. Yousef, go ahead.
Yeah, just very briefly on this issue of platforms, both social media platforms and financial platforms, and Israeli government's objectives here. These were outlined pretty comprehensively in a document released by the Israeli Ministry of Strategic Affairs in February of 2021, where they reviewed sort of where online platforms stood with their policies of taking down or closing down accounts. And what they wanted to see change. And this document is very instructive and focuses on the government wanting to see these social media platforms increasingly adopt the IHRA definition of anti-Semitism as the guideline, as the standard to enforce removing content or closing down accounts, and also wants to see civil society partners of the Israeli government help promote these new standards. And I think this just underscores how much the IHRA definition is the new sort of preferred weapon to silence dissent, because of the way it can be implemented so broadly. And I think one thing that we have to recall here is that just calling into question whether or not certain speech is anti-Semitic. The example that Meera gave of this student who included the words "Free Palestine" in their presentation. Just the prospect of maybe being investigated is itself a coercive force against these students. So even if these investigations end up coming back saying, yes, of course, this is absurd, this is protected speech, this is not anti-Semitism, the very specter of having to go through that, right, is a repressive force in itself. And that is, of course, the goal here, to silence, intimidate, and coerce people away from critical speech of Israeli policy.
Thank you, Yousef. Maria?
Yeah, just a few things. I mean, I'd like to say just boycotts of Israel for violating human rights are not discriminatory. They're not boycotts of Israelis or Jewish people. They're refusals to be complicit in Israel's international law violations. They are actually demands for equality. So I do think that needs to be debunked once and for all. Marta, your question about 501c3s, feel free to reach out to me and I can connect you with others. There's, I think, exposure is something that can be done, letting people know that US tax money is being used to support these nonprofits, essentially by tax deduction for funding settlements and funding settler violence. So, the IRS has received many complaints that they haven't acted on. So you could also pressure the IRS to review 501c3 status. State attorney generals also have the authority to dissolve nonprofits for, in certain ways. So that's another thing that can be done, but feel free to reach out to me. I think the deplatforming question, just to add, there could be legal recourse. Material support laws cannot reach independent advocacy. So I think that's something that could be, looked into creatively challenging. So thank you.
Thank you, Maria. Brian?
So first on this question of whether boycotts of Israel are political, I think they're indisputably political. The distinction that the case law sometimes draws in terms of protected versus unprotected boycotts is, whether it's political or whether it's economic. And what the court really means there is if the speaker is boycotting to assert their own economic self-interest, right? If I'm collectively with a bunch of other manufacturers saying, we're not going to sell to this supplier, we're not going to buy from this distributor in order to squeeze them out of the market, that violates the antitrust laws, and the First Amendment doesn't protect that kind of activity. But where the person participating in the boycott doesn't stand to profit financially, and instead their goal is to effectuate social change and vindicate human rights as they see them, that's squarely in the heartland of the First Amendment. I think one thing that defenders of the anti-boycott laws have tried to argue in distinguishing this issue from Claiborne is say, well, Claiborne was a civil rights issue. That was a domestic legal issue. It's about vindicating rights under the Constitution. This is a foreign policy issue, and the First Amendment provides less protection there. And again, the Supreme Court has just squarely rejected the notion that political speech on foreign policy, which is one of the things that's at the heart of national debate constantly, is entitled to any less protection than domestic political speech. So in a case called Booz versus Berry, where people were protesting, for example, outside the Russian embassy, the Supreme Court said that that protest was just as entitled to just as much constitutional protection as a protest targeting Congress. They're both protests on matters of public concern that the public has a right to hear, and so they're protected by the First Amendment. Lastly, on this question of whether BDS boycotts or boycotts of Israel are anti-Semitic, I think there's obviously a lot of disagreement about what constitutes anti-Semitism. It's not a stable definition. I certainly, as a personal matter, think it's absurd to suggest that somebody who's boycotting Hewlett-Packard because they contract with the Israeli Defense Forces is anti-Semitic because of that decision, or because they're targeting Hewlett-Packard instead of some other company operating in another country. The debate over what is or isn't anti-Semitic is, of course, an important debate to be had, but it is not a debate that's relevant to the First Amendment question. And there's a very, very important reason why that issue has been taken off the table when it comes to First Amendment protection. The fact of the matter is, whenever the government wants to suppress disfavored political dissent, it will concoct a justification that supports that censorship decision. And when you have these categories of supporting affirmative action, racist or not, people are going to hotly disagree about that. If the government can censor speech based on one side's definition of what is or isn't racist, or is or isn't anti-Semitic, then that is going to be the tool to suppress political dissent across the board. And that's exactly why the First Amendment removes that issue from the question about whether the government can censor political protest. Thank you.
Meera, the last word is yours.
Just really quickly, I think I will just, I think Yousef and Maria covered the deplatforming, but I would just point people to the resources of Hemla, a Palestinian human rights organization that has been documenting censorship on social media and in the tech context more broadly. So check out their resources. And then, I think just to circle back, in terms of BDS and sort of this whole conversation, I think going back to the false accusations and how they sort of underlie a lot of these issues, and the importance of pushing back on this conflation of criticism of Israel with anti-Semitism wherever it appears, in the narrative context, in the legislative context. I think that is absolutely critical. And remembering, two things, both that, coming back to what this is about. It is about justice and equality and freedom for Palestinians. And that, to keep the focus on that part of the conversation, and also to recognize also that, these smears are chilling and that they are, very impactful, especially these charges of anti-Semitism and terrorism, and to sort of know both that you're not alone, and to seek out resources, but again, to kind of go back to what this is about, and why people are advocating in support of Palestinian rights and calling for boycotts. It is about Israel's violation of Palestinian human rights, and sort of to keep the focus on that, I think.
Thank you, Meera. We've come to the end of the time we have for today's discussion. On behalf of Arab Center Washington, D.C., I would like to thank you, all the speakers, for your time and your insightful contributions. I would also like to thank the audience for tuning in. There was a question about the video. So the video of this discussion will be available on our website immediately after this. Feel free to watch and share. Please stay in touch and follow our programs at arabcenterdc.org. Thanks again to the speakers and to the audience, and we look forward to seeing you at future events. Take care, everyone.